Minister John Halligan, you're very welcome, and your assistant, Ms Maureen O'Sullivan, you're very welcome. Minister, I'll invite you to make a presentation, and when you conclude, then I'll afford members an opportunity to ask any questions they may have. Before that, I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to so do, you're entitled thereafter only to qualified privilege in respect of your evidence. You're directed that only evidence connected with the subject matter of these proceedings is to be given, and you're asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the House or an official, either by name or in such a way as to make him or her identifiable. Once again, if you have mobile phones, you might turn them off, please. And Minister, if you'd like to make your opening statement.
Thank you very much, Cahir, and thank you, members. Can I first say this is the Social Welfare Consolidation Act 2005, Specific Bodies Regulation and Select Committee on Employment Affairs. Can I thank the Chairman for the opportunity to come to discuss with the Committee the Social Welfare Consolidation Act 2005. And this is Specific Bodies Regulations 2019. My officials have provided the committee members with briefing material for use at this meeting. These regulations will support an important anti-money laundering measure. The Central Register of Beneficial Membership will identify who is behind a corporate entity. The regulations prescribe the new position of Registrar for Beneficial Ownership of Companies and Industrial and Provident Societies as a specific body for the purpose of Schedule 5 of the Social Welfare Consolidation Act 2005. This will enable the Registrar to collect PPSNs to verify the identity of persons who have ultimate control of a company, making sure that the Central Register is accurate and to prevent individuals who would think of trying, if you like, to conceal their identity for the purpose of money laundering or financial terrorism. The PPSN will not be visible to the Register or to the staff within the Registry of Beneficial Ownership or to any member of the public. The PPSN will never be shared with any state or non-state competent authorities or with any third party. While members of the committee will be aware of the company law and the concept of directors of company, a beneficial owner is a natural person or persons who ultimately owns or controls a legal entity through direct or indirect ownership, or through control via other means. This is to say that just because someone is director on paper does not mean that in practice they ultimately, if you like, control the company. Recital 25 of the EU 4th Anti-Money Laundering Directive highlights the importance of beneficial ownership information, and it states that the need for accurate, up-to-date information on the beneficial owner is a key factor in tracing criminals who might otherwise be able to hide their identity behind a corporate structure. The globally interconnected financial system makes it possible to hide and move funds around the world, and money laundering and terrorist financiers, as well as other criminals, have increasingly made use of that possibility. In order to prevent this criminality, the EU 4th and 5th Anti-Money Laundering Directive, also known as 4 and 5 AMLD, legally oblige Ireland to establish and also to maintain a central register of beneficial ownership of companies and industrial and provident societies. This central register, or it's known as RBO, is the first in a series. Others are currently being finalised for trusts and for the Irish collective asset management vehicles, or ICAVs, as you may know of. Crucially, Article 30, Paragraph 4 of 4 AMLD means that there is a EU legal obligation on Ireland to ensure that the central register is accurate. PPSN use is seen as critical to the success of the RBO, as it will prevent, if you like, multiple variations of the same person's details from being entered in the register. While a mechanism will be in place for beneficial owners who do not have PPSN, the vast majority of beneficial owners already have PPSN, particularly for tax purposes. A practical example of why such verification is needed is the charity console. In 2016, when concerns were raised about the governance and financial management of this particular charity, it was identified that the former chief executive and his wife were connected to 12 other companies. However, in official documentation submitted to the company's registration office, different dates of births and signatures were provided at the time, along with use of maiden names for some entries and a married name for others. I'm sure members will agree with me that this is not something that we want to see ever happen again. The online register combined with the PPSN verification will ensure that such scenarios are prevented. To ensure personal information is protected, the PPSN is encrypted, not visible to the RBO staff, and is used only as, if you like, a specific point in time, i.e. the point of filing, as it's called. To validate the PPSN and date of birth against the data that the Department of Employment Affairs and Social Protection hold for that PPSN, where there is not a match, whether by accident or intent, that beneficial ownership information cannot be filed. The PPSN will not be visible to staff within the RBO, as I've said, or the CRO, as it will be stored in an encrypted form. RBO staff and officials from the Department of Business, Enterprise and Innovation have worked closely with the Department of Employment Affairs and Social Protection in consultation with the Office of Data Protection Commission to ensure that the appropriate safeguards are in place to protect personal information and that there is a lawful reason for processing PPSN data. While the obligation to file with the RBO is new, relevant entities have been required to hold such beneficial ownership information since 2016 under the European Community's Anti-Money Laundering Beneficial Ownership of Corporate Entities, and that Act was 2016. The RBO and filing requirements are provided by SI number 110 of 2019, entitled European Union Anti-Money and Laundering Beneficial Ownership of Corporate Entities, Regulation 2019. Under SI number 110 of 2019, the RBO has been established from June 2019. While the staff and ICT infrastructure of the company's registry office, CRO, have been utilised in the technical development of RBO SI number 110 of 2019 provides for a new statutory office of Register of Beneficial Ownership of Companies and Industrial and Provident Societies. Therefore, while the CRO is a specific body under Schedule 5 of the Social Welfare Consolidation Act 2005, following legal advice and to ensure, if you like, legal certainty, the current regulations designate the Register of Beneficial Ownership of Companies and Industrial and Provident Societies explicitly and separately as a specific body for the purposes of PPSN. As such, the opening of the RBO has been postponed to allow for the necessary consultation to be undertaken with both houses of the Oireachtas and following referral to this committee. While all previous designations have been done by primary legislation, given the need to resolve this issue as a matter of urgency, and why I say that is that already we are facing fines from the European Commission, who have referred this to the Department of European Justice. So it's imperative that we get this through as quickly as we can. Almost all other European states are working on this. Some of them are delayed, as we are. That's why I'm saying this is a matter of urgency. To allow, before we can allow the central register to open. The most appropriate course of action is for the RBO to be designated by means of statutory instrument. The 2005 Act does allow for a specific body to be prescribed by SI, and these regulations provide the most appropriate course of action to facilitate the opening of the central register to minimise the impact of wider infringement proceedings against Ireland for failure to transpose all aspects of 4AM LD. I would like to advise the committee that this SI will be temporary and the regulations will be confirmed in primary legislation at the earliest possible opportunity. The collection and maintenance of beneficial ownership information is an EU requirement and part of the larger effort by Ireland and EU internationally to combat money laundering, organised crime and terrorism. And beyond this, the RBO is a mark of Ireland as a global, modern and open country, if you like, promising best international standards in the transparency, business and global and connected financial system. Thank you very much, Chair.
Thank you, Minister, for your opening statement. I think a number of colleagues might have a few questions, so I'll start with Deputy O'Dea.
Well, thanks, Chairman. I want to welcome the Minister and thank him for his presentation. You know, I suppose we live in an era where our privacy is under constant threat, but sometimes we have to make concessions in that regard for the greater good. Now, there's a couple of points the Minister makes during the course of his presentation, which I think are fairly central to why we shouldn't oppose this. He says that on the second page, he says Article 30, paragraph 4 means that there is an EU obligation in Ireland to ensure that the central register is accurate. And, you know, the experts tell us that in order to ensure the accuracy of the central register, which is an anti-money laundering device, PPS numbers are necessary. The other thing the Minister says is to ensure personal information is protected, the PPSN is encrypted, not visible to RBO staff, and is used only at a specific point in time, at the point of filing, to validate the PPSN and the date of birth against the data which the Department has. And I'm glad he's given that assurance, and I hope that that will be honoured. The Minister goes on to say, I think towards the end of his presentation, that this will all be confirmed in primary legislation anyway. This is a temporary device to prevent the EU from fining us, and that ultimately it will be confirmed in primary legislation. So from that point of view, I suppose the place to have a detailed debate on this is in the primary legislation.
Just if I could very briefly,
very
important points that Deputy O'Dea makes that. As I said, the data sharing agreement has been put in place with DEISP and includes an encryption process. And the Office of the Data Protection have been informed of this, and an impact assessment has been carried out by the Office of Data Protection. And again, I have to emphasise this, that all RBO staff are GBR trained, GDPR trained, and further information is available in the privacy statement. On the primary legislation, again, the reason why we're trying to get this through as quickly as we can, and I know we allocated half an hour, is that we are under serious pressure from the EU, and this has gone, if you like, the Commission himself has criticised us for not getting this through. But what we are going to do is bring primary legislation to the Dáil and the Seanad, which allows all members to debate it in its entirety, put amendments if they wish to it, and I will be able to then, or some other minister probably, will be able to bring detailed information on all aspects of this piece of legislation.
Thank you. Deputy Carey, did you want to comment, or are you okay?
Thanks, Chair. No, I just want to commend you, Minister, and also Minister Doherty, and for your work on this particular issue, and I support it entirely. Just want to know maybe how advanced is the legislation? You say you're working on it. How advanced is it? What stage is it at? Is it with the drafters or?
No, it's not ready to draft yet, but we are doing all in our power, because you know this is a crucial piece of legislation, and we are working on this at present, and our intention will be to get this as quickly as possible before the Dáil. The basis of the legislation is basically, it's a short remit, if you like, in what I have said. I know it has to be more detailed and go into, you know, the staff, personal, what are other countries doing and so on, what is the definition of beneficial ownership. And it's probably likely to be part of larger legislation. We are working on this as feverishly as we can to get it through to the Dáil.
Can I ask you just a general question? The EU 4th and 5th anti-money laundering directives, when did they come into being?
I think they were 2000, and was it? Did they bring them in 2016?
27.
Or was it 20? But was,
Should have come in.
they should have come in, shouldn't they? Yeah.
The 5th is early 2020.
Yeah. 2016, 2017, and confirmation early 20.
Okay. Just one other question, because Deputy O'Dea touched on it, and you're aware in general around the public service card and the
Yes.
data protection officer
Yes.
that there has been some concern about
Absolutely.
the use of PPS numbers. We understand that the Data Protection Commissioner has submitted to the Department of Social, not your department, Department of Social Protection, a draft report on that. And you quite clearly indicated that this had been referred to the Data Protection Commissioner.
Yes.
In light of which we haven't seen, in light of the report that the Data Protection Commissioner has submitted to the Department, what specifically did they say about the use of the PPS number in this particular context? And specifically when you said that there was a mechanism in place for beneficial owners who do not have PPS numbers?
The present assessment has been carried out. I haven't seen that, to be honest with you, what they have said on it. This will be for the larger legislation. But I will say this, that if you look at beneficial ownership, the absolute only and corroborative way of finding the ownership of a company, if somebody is registered to pay their tax and the PPSN number, that gives a name and it gives an address and it gives verification, and that's why we're putting a particular emphasis on that. We understand, and I understand, that there are difficulties with the privacy of your PPS number, if you like, but all we can do is give a guarantee, and we have done an assessment on this, that this is, by the way, this is how they do it throughout Europe, the best collaborative way of getting information of the name and ownership is we can absolutely collaborate. If you give a PPSN number, we can check with the Department of Social Protection on that to say, yes, this is John Halligan, this is where he lives.
Have you referred to it, and the briefing notes we got specifically said the Office of Data Protection Commissioner has been consulted?
Yes.
What did they say?
We haven't had a feedback from that. Yeah. They agree with what we're doing with the PPSN number. That's absolute. They've said that there isn't a problem with that. But in the larger element of the legislation itself, they are kind of assessing that. But regarding the PPSN number, there's no problem.
In this context, I'm talking about.
Yes, in this context
specifically.
Yes,
yeah.
There's no problem.
Okay, Deputy Brady.
Just one quick query there, Minister. At one point you went off script here, and you mentioned that we're under pressure, obviously, to impose this, and you outlined that a number of other European countries have already done it. Some are in at different stages in the process. Correct me if I'm wrong. Did you say we're facing fines or penalties, or we are currently, I suppose, receiving fines or penalties?
Well, we have been referred to the European Court of Justice.
Okay.
By the Commissioner, and I have to say that infringement proceedings have been initiated against us because of our delay. Now, I think that may be the same with other countries.
When were those proceedings initiated?
When were they initiated? Earlier this year.
Earlier this year.
Yes.
Pretty happy? Okay.
By the way, it's important that I go back to the Data Commissioner. I just want to be on record on this. What they have said is, and I actually have it here, they agree with the PPSN as long as we follow protocols and procedures in that. On this particular piece of legislation. Yes, I have to be quite clear on that. It's this particular legislation.
Minister, we're not being awkward with you. It was an issue that this committee has spent quite some time. We're aware that the Data Protection Commissioner had has an interest in it, and it was in that context we needed to question you.
No problem at all.
Thank you for your answers. Colleagues, that concludes our consideration of Social Welfare Consolidation Act 2005 Specified Bodies Regulations 2019. In accordance with Standing Order 90 of Dáil Éireann and Standing Order 75 of Shannon Éireann, a message to the effect will be sent to both the Clerk of the Dáil and the Clerk of the Seanad. Minister, I'd like to thank you for your attendance today. Have you any, unless you have any concluding remarks?
No, just to assure the committee who represent all of the Dáil that this further legislation will be brought to the Dáil on this. And of course, when we bring legislation to Dáil and the Seanad is open for scrutiny, amendments and further questions.
Minister, thank you very much. That concludes our meeting for today, so this committee now stands adjourned.